Your Honors, the matter before the court this morning is the case entitled Victor Calderon versus Brown Certified Welding et al. Case number 24 AP136. Representing the appellant, Victor Calderon, is Patrick Daniels. Representing the appellee, Brown Certified Welding et al., is Doreen Connor.
All right, good morning, counsel. For the appellant, please introduce yourself and your client, and you may proceed. You have 5 minutes.
Thank you, Your Honor. This is Patrick Daniel on behalf of the appellant, Victor Calderon. May it please the court. Your Honor, from the plaintiff's perspective or the appellant's perspective, we think this is a fairly elementary and straightforward issue. The plaintiff was previously represented by an attorney that ultimately withdrew on December 15th of 2023. December 18th of 2023, the court notified the client that a withdrawal had been completed and that in 30 days that he would be required to either enroll himself or find counsel. Within that 30-day period of time, on January 2nd, the defendants moved for summary judgment. The issue during that time period is that, as this court is fully aware, under Rule 79.1, specifically 79.1G, there is a stay according to the Pope versus Birchwood Manor case. In other words, there can be no action taken during that time period by any party contrary or in any way prohibiting or limiting the rights of a party. The reason being, according to the Pope versus Birchwood Manor case, is that it diminishes the rights of a plaintiff or any party for that matter to a secure counsel. In other words, what would happen is exactly what happened in this place. For a person to go out and solicit counsel, they go and look at the record of the matter and see that there's a pending summary judgment. And what occurs is it diminishes the right or the ability of someone to obtain an attorney, which is specifically what happened in this case. Now, moving forward, the second thing that would happen is, in this case, they then move to extend a deadline. You have an attorney or a person going to seek an attorney, and you have motions that are getting filed when you have no counsel of record. And then all of a sudden you have things that are getting granted, like the defendant is extending deadlines for themselves. They're moving the deadlines in a case so that they can extend their experts and they can do various things themselves. Now, as these things go forward, these things also have problems. The defendants are serving things on a plaintiff that doesn't have an address of record. So the summary judgment gets filed at the wrong address. The plaintiff doesn't have any address of record. And as a consequence, the defendants serve the motion for summary judgment at an address identified as 19 Lexington Road in Colchester, Vermont. Now, 2 weeks after that, on January 18th, 2024, when the plaintiff doesn't successfully secure counsel and he enters his 79.1D appearance by a self-represented party, he identifies a couple of things. He says, one, I'm not going to accept e-service. And two, my address is 93, not 19 Lexington Road, 93 Lexington Road, Colchester, Vermont. So what's occurred at this point is, during this period of stay, the defendant has served the summary judgment. First, that's in violation of Rule 79.1G. But second, they've served it on the wrong address. So moving forward, the defendant now has served the summary judgment in violation of the rule. And second, they've served it at the wrong address. Now, moving forward from there, what happens is, despite the fact that the plaintiff has initiated under Rule 79.1D his right to not be served electronically, the defendant begins serving everything in the case electronically. Now, the court during this time period, with all of the notices of hearing, is serving the plaintiff by mail at the address he has on file. So the plaintiff is doing what he can at that point to attend things and appear for things, all the while filing handwritten motions with the court to attempt to continue various hearings, motions, and request additional time from the court. Now, his motions are being met with denials, while on 3 different occasions, and mind you, during this time period, there is no trial date whatsoever, the court denies all of his requests for additional time to secure counsel, but the court extends the defendant's expert deadline 3 different occasions. Yet the plaintiff, who's pro se, has no opportunity to continue to secure counsel, has a summary judgment filed during a period of stay that's not served on him, mind you, and then all of a sudden the court rules on the summary judgment and alleges that he wouldn't have been able to secure an expert as the basis. So from the plaintiff's perspective, Your Honors, we have a situation where we have a judgment that is void through a lack of due process because the document, the pleading itself, was never served on him because it was not served on him. It was served, even if we take everything out of the equation, it was never served on him at his address.
All right,
It was
counsel, you're gonna need to wrap it up here. You're out of time. I'll let you finish that thought.
I apologize, Your Honor. The
That's
the
okay.
moral of the story is it was void for lack of service of process, and we believe that the uh, other problem is it was defective because they filed their summary judgment during a period of stay in violation of 79.1G in the Pope versus Birchwood case, Your Honor.
All right, thank you very much.
Yes, sir.
Counsel for the appellee, please introduce yourself and your client, and you may proceed with your argument. You have 5 minutes as well.
Thank you, Honor. May it please the court, I'm Doreen Connor from Primer, Piper, Eggleston, and Kramer, and I represent the defendants. The defendants are here today asking this court to affirm the summary judgment ruling. Following 3 extensions of the discovery schedule, which the plaintiff filed in a case that was nearly 2 years old, the plaintiff, while he still had counsel, filed his expert disclosures. He filed a disclosure identifying 3 medical experts, no liability experts, in a case that alleges an unreasonably defective product, breach of warranty, and negligence. Pursuant to well-settled Vermont law, it must have expert testimony to proceed with that. His deadline was October 1st, 2023. 3 months after the defendant's motion for summary judgment, the court scheduled a hearing for the specific purpose of providing the plaintiff, who at that time was pro se, a hearing. The trial court did everything they could to give this gentleman an opportunity to oppose the motion for summary judgment. In fact, at the hearing on April 9th, 2024, the court asked Mr. Calderon whether he had seen the papers Ms. Connor filed, the motion for summary judgment. Mr. Calderon answered, "Yes, ma'am." That's at transcript page 3. In his brief, Mr. Calderon also admits receiving all of the notices from the court. The first notice from the court was issued on January 3rd. It is a standard notice to a pro se defendant advising them of the impact of a motion for summary judgment and its time to respond. After that, the court notified Mr. Calderon on February 13th, February 14th, and April 3rd, all about the motion for summary judgment. And the court specifically said, "We're having a hearing to give you an opportunity to respond, even though you haven't filed a written response." On April 5, 2024, Mr. Calderon acknowledged to the court that he understood there was a hearing for a motion for summary judgment coming up, but that he wanted to attend by WebEx because he was at this point living in Texas. That is in our supplemental printed case at page 5. At no time prior to the court granting his motion, my motion for summary judgment, did Mr. Calderon ever raise a notice issue. The court gave him every opportunity to respond. Even if Mr. Calderon did not receive the defendant's motion for summary judgment, which is the defendant's dispute, he was on notice from the court that we were having a hearing, and he took no action. He has failed to preserve a notice challenge. Finally, as noted by the court on the motion for reconsideration, Mr. Calderon still does not have expert witness testimony. He never filed a motion for additional time. He was represented by counsel when his expert disclosure ran. He could not prevail, regardless of when the defendants moved for summary judgment. This court should affirm the summary judgment order, and we rest on the pleadings.
And what do you say about the Rule 79.1 stay issue?
Your Honor, that was not raised in the brief. It would have been nice had it been raised in the brief, but regardless of the timing, the court extended the deadline by which he was to respond to the motion for summary judgment. The court asked for any evidence he had to respond to the summary judgment 3 months later. So he had more than sufficient time. He had 3 months to address that issue.
All right, thank you very much. All right, does the appellant have any time remaining?
The appellant has no time remaining.
All right, the bailiff may call the conclusion of this